Thanks, Danielle. Good morning, ladies and gentlemen. Welcome to our 10 key tips of representing buyers. What I did was just sit down and tried to talk about 10 different things that are important to buyers that you can work with. Some of you have seen this, I think, before my Champion Creed, but it was put on by Tom Hopkins, was a sales trainer. And my point of saying this is I'm not judged by the number of times I fail, but the number of times I succeed. And the number of times I succeed is in direct proportion to the number of times I fail, but keep trying and keep trying. And I think that's good philosophy. You know, you look at something, you're going to see something today or even in the future, and you go, I don't know if I can do that. That's not the way I do it. Well, my point is try it. You're the only one that would know that you screwed it up. It's like me when I do a webinar. If I make a mistake, likely I'm the only one that realized I made a mistake. You may not have because you weren't listening that close or something. So don't be afraid to try something and see if it works. If it doesn't work, you stop. If it does work, keep going. The other reason that I think these 10 tips are so important, and I'm a great believer that you have to have some kind of a presentation to buyers and sellers, and today we're talking about buyers, to show them why you're important to them and you're worth something. I'm going to give you a quick scenario. I had some landscaping done on my property this fall, or this summer, and I contacted a couple of people, and one guy was right back to me and said, I'll come over, I'll take a look, and he took pictures and that. And then he came back, and what impressed me was when he sat down to talk to us about his process, he first of all had two choices, and he said, he went through it very thoroughly and said, now think about it and let me know. But when he came back the second time, and I had no idea he was going to do this, or I didn't suspect it, but the first thing he took out, and I'm not saying you do this in real life, but it shows the presentation. He said, I want you to show you, here's a contract that I have that I'm insured to come onto your land. We have washrooms. We bring our own washrooms with us. We do this, we do that. And it was all informal, but it was formal that I knew what was happening. And I was really impressed with that. So that's the idea, that you have to impress your buyers. And we went with the deal, and it was very successful. The other thing is RICO Consumer Survey talked in 2014, and this still is very thin. 45% of buyers needed a better grasp of the buyer process. They had no idea what they were really doing. 33% of the first-time buyers did not feel prepared and knowledgeable about the process. So that's my point. You've got to tell them. 52% believe the agreements are standard. They did not understand terms. You can change it. You work for me. I can change it to work whatever you need to do. 43% did not fully understand the agreements. That's why it's important to give them agreements. 36 thought that it was a trial period, you know, and we've had that fight for many years. I've been around for many years, and some of you have been too. But every so often, the government gets an idea that we should have real estate should be a trial period. You know, they should have a cooling off period. And we've always argued, no, that would be disastrous. But they thought they did. They didn't understand you could represent both the buyer and the seller if you needed to. And 55% that believe that if a deal failed, you automatically get your deposit back. It was just, you know, so what, I terminated the deal, I get my money back. So those are important things to do that. Today's real estate, I keep saying to you, and I'm going to give you the slides, is you can be a consultant and advisor. And I'm so happy that the new act has come into effect, part of it, not all, but as of October the 1st, and you now can change, and many of you know this, but is this so important, what I think you can do? The Code of Ethics has now been amended to now permit you to use real estate broker or real estate salesman. Agent, broker of record remains the same. So brokers, if you are a broker, you may advertise as a real estate agent. You may advertise as a broker real estate agent. You can use the word realtor only. You don't have to use salesperson anymore. And I think that's so important, because I've always argued that you're not salespeople. We're consultants, we're advisors. Or realtor broker that you can use. So you can use any of these terms, descriptors, to describe yourself in your new advertising. Now, if you're just a salesperson, and I don't mean that just a salesperson, but a real estate agent may be just a real estate agent. Or you can be a realtor or a realtor, real estate agent. So it's all there to allow you, and so you get away from the word salesperson. You don't have to change it immediately, but this is possible. The important thing to remember is, which I'm sure all of you know that, is realtor must be in caps with the R sign, because realtor is the trademark by the Canadian Real Estate Association, and that's why it was allowed. So this is only allowed if you're a realtor. Just so you know that if you're doing a publication now, the first words have to be capitalized, realtor, but in subsequent uses only R needs to be capitalized, and no R is required. So if you were writing a paragraph or something like that, the first one has to be caps, but the way after that it's just a capital R, and it's there. And as we say, realtors organize real estate. So if you're a member of board, which you are, therefore you're a member of Korea, therefore you can use this. If you're a non-member of a board, you cannot use realtor or realtor, that word in any way. So I hope that helps you. These 10 tips should assist you with buyers. First of all, setting up appointments. And some of you who have heard me and seen me and Barry would have heard this before, but I think this is so important to do. Your buyer representation agreement says very specifically, the buyer hereby warrants that the buyer is not a party to a buyer representation agreement with any other registered real estate broker for the purchase or lease of real property in the general description indicated above. Now, my argument is, to a normal buyer, they go, so what does that mean to me and why do I care? This next scenario I'm doing, and this is being recorded, you can use this as if you want. If you want the PowerPoints, let me know and I'll give them to you. But what is important is that you are here, and the scenario I'm using most of the time here, but you can use this on anything, is when you get a call from a buyer you don't know on a sign or something like this. But if I was going in and talking to a buyer, you can still use this scenario in many ways. So first of all, somebody calls you and says, I want to know about such and such a property. And I've always said this, to set up an appointment, you should always use an alternate, is 6:30 or 8:30 okay? Now, understand we've had a long conversation about the property, and you told them it was a 4-bedroom, a 3-bedroom, it was this, and this, and this, and they said, yes, we want to see it. So that's where I come in. Lots of them are going to say, thank you very much, goodbye. But this is somebody that said, yes, I think we want to see this. So I'm saying you always use an alternative choice. Is 6:30 or 8:30 okay? Is tonight at 6:30 or tomorrow night at 8:30? It's a lot harder to say no. Now, here's my point is, you as a real estate agent say that sounds great, but before I set up an appointment, I need to ask you if you have signed an agreement with another real estate agent. The reason I am asking you this question is due to our professional code of ethics, which states we cannot interfere with another real estate salesperson's contract without their permission. At this point, the buyer is saying to you, who gives a damn? I have no idea about your code of ethics. I don't care. I don't understand what you're talking about. So they don't care, but you have to talk to them. So the caller basically says, I don't see what showing a house has to do with me signing a contract with you. They don't understand it. So then we go further. And you say, well, I know you don't think that's a big deal, but I would be in violation of my professional code, and I can't interfere with somebody else's real estate salesman. Now, here's where you start to get them. Mr. Buyer, I understand your concern, but I'm here to protect you. And that's why I'm saying you can talk to them when you're sitting in your house trying to sign them up with a buyer agency. You tell them, I'm protecting you by having it signed. And that's why I need to know, do you have an agreement signed with anybody else? Because if you have an agreement signed with anybody else, you could be liable for 2 commissions. Now you have their attention. They go, whoa, okay. Nobody's ever talked to us about that. I certainly don't, and my point is, I certainly don't want to place you in that position. So, please, and then, so you talk about that. The next thing that really gets them is, please know that I will show you a property. I will require you to sign the agreement with me. So in other words, if we're going to see 14 Lilac Court, when we get to see it, whether I'm picking you up or I'm meeting you there or whatever, before I show you the property, I'm going to ask you to sign an agreement with me and it's only for 14 Lilac Court, but I will get paid for that deal, that house, if you buy it. And I don't want to put you in a position that somebody else may try and get their commission too. And now they understand that. I have a question.
Mario says, buyer, have you signed a buyer representative agreement with another brokerage, question mark, correct?
Yes. Yeah, Mario's right. I mean, when I say with another real estate agent, it really means another brokerage. Absolutely. Because all our agreements, our buyer representation agreements, our listing agreements are all with the brokerages, not with you as an individual. And yeah, he's absolutely right. So now I've got their attention. And I'll just tell you when I think of this here, you know, that's great. I will get back to you and set up an appointment in a few minutes. But the point I'm getting at is, and I know there's people in Barrie that do this. I would do this all the time because you're going to run yourself ragged. You know, people are going to come from Toronto and all over the place, and you're going to, oh yeah, and then they're going to say, well, don't worry, I didn't bother my salesman tonight because he was busy, or he didn't want to drive from Toronto. He wanted you to show it, and I'm going to do that. No, I'm going to cut you off in the past. So don't be afraid to do that. The question I get all the time is, yes, but it's my listing, and the seller, when I go to the seller and say they're not coming in, he goes, why? And you say, because they wouldn't sign an agreement with me. They go, well, are you really working for me? And my argument is, yes, I am. Because in this case, I don't know who these buyers are. I don't know if they qualify for your property. I don't know if they're just out to see it, to come back and rob it. I have no idea who these people are. Normally, when I work with buyers who I've worked with and got them qualified, when I show your house, or when another salesperson shows you a house with a buyer, they know exactly what they can qualify and can they afford. So don't be afraid of defending it. Number 2, showing tips. We talk about caveat emptor all the time, and there's no question about it. Caveat emptor is very much alive and well from a legal point of view. And what that means is let the buyer beware. And that's true. But we break it down, and some break it a little different, but I do, is you've got patent defects. Those are minor defects visible to the buyer. For example, you know, it's an old house that's 100 years old and there's no closet at the front door. There's no lights in the ceiling. There's no heat in the back bedroom, or the chimney needs to be pointed. Those are patent defects. Latent defects is the seller is not aware of this. He did not know there was a problem at all, and the buyer bought it. That's caveat emptor. So in other words, if the buyer bought it and the seller knew nothing about it, then that's latent defect, and that is caveat emptor. Undisclosed defects are very different, though, and some people call them a little different, but it's an undisclosed defect. In other words, if the seller knew there was a problem with the basement, it leaked a year ago, and he repaired it, then my point would be that is undisclosed. He should be telling you, yes, we had a problem with the basement, but it leaked, but we fixed it. Now I have fully disclosed it. I always say the easiest example to use, and some of you have heard this because I've used it for years, is the simplest example, but they understand it. So in other words, Mr. and Mrs. Buyer, if you bought the house and moved in, and 3 weeks after you moved in, the furnace blew up, then the point is, did it blow up just because it's 3 weeks old? And if it did, and the seller knew nothing about it, that's caveat emptor, that's latent defect. If he knew, or the seller knew, there was a problem with the furnace when they sold it, that's an undisclosed defect, and you likely can sue and get your money back. So they understand that. So make a very simple explanation. How do you use patent defects to your advantage in showing a property? Remember, when you take a property and you're working with buyers, I don't care whose buyers they are. I'm talking about residential here. I'm not talking about commercial. That's a whole different story. But when your residential buyer enters the house or shows up and says, oh, we like the curb appeal, we like the area, they like the property. So they like the property you're showing them. If they dislike the property, so if they like the property you're showing them, and you know that, whether they said anything or not, when you walked in the first door and started, you know, people say, well, I wouldn't know for the next hour. Yes, you do. You know that. When they walk in, they go, why are we here? This is a dump. Or this is really nice. Not that they're going to buy it, but they like it. So my point is, if you point out patent defects to them, they think you're wonderful. They're not, because what do they say? When you say, oh, by the way, this house is a century-old home, and did you notice at the front door there's no closet? And they go, yeah, but it's a century-old home. It shouldn't be there. Or did you notice there's no heat in that back bedroom? And they go, we don't care. We wouldn't use. We're just going to use it for storage. So they do that. So if they like the property, patent defects mean nothing to them, but it helps you develop credibility that you're talking about it. They dislike the property. If you dislike the property, and if they dislike it, the reason they dislike it is because of all the patent defects. You know, we won't do this, we won't do that. And if I had time, I'd give you some examples, but you know that. Is it okay for the buyer to take pictures of the property they are viewing? And the answer is absolutely no. Now, you're going to have them. They're going to take them with cameras today, and with their iPads, they take them all the time. Phones, they just snap them. But they shouldn't be taking them without permission. That is a privacy issue. The other thing that I think is very important, if you don't do this now, is talk to your buyers. And this is when you make a presentation to them. They look at you like you really know what you're talking about. As we get out, Mr. and Mrs. Buyer, I want you to be very careful of what you're posting on social media. I'm not saying they can't say we're looking for a house, or we're looking for a home, or we're whatever. But when they get too complicated into it, it could cause them problems with the seller. Comments come back to the seller. Harm for the buyer's negotiating level. I listened to a program on the radio where the lady told me, she said, I listen to everything they say, and she said, I negotiate based on that. Now, you can argue, are surveillance cameras legal? Are they not legal? Whatever. I don't know. But you're not going to argue that case. You're not going to go to court over it. They're going to do it. They're going to record you and things like that. So be very careful what you're saying. So tell your buyers outside, or when you first sit down and talk to them, let's keep comments. It doesn't mean they can't ask you specifically about the property, but let's not keep it to the fact that it's a busy, oh, I love this house, I could really live here, and this is wonderful. Like, you keep those comments to yourself, because I work for you, Mr. Buyer. The seller is a customer of ours. We're going to treat him fairly, but he's a customer. So tell them that. Inclusions. I think this is big, but many people don't do them. Obviously, when you're sitting down and talking to a buyer the first time and qualifying them out what they need and how much they can afford, etc., the other thing you should be talking about is appliances. Now, maybe they're in an apartment and they need appliances, and they forgot all about those. They didn't realize that. So you're saying to me, you're in an apartment, do you own these appliances? And they go, no, they belong to the rent, to the apartment. Well, then when we buy a house, you maybe need a fridge and stove, right? And they go, yes, we do. Now, maybe they own a house and they got a brand new fridge and stove. It's not significant. My point of this is, when you're showing a property and you know the buyers want the appliances, you make a mental note. Don't take pictures, but you make a mental note to yourself to say, that's a stainless steel GE fridge and stove. And when you get outside after showing the property, wherever it's in the car going home, or you're just talking to them on the lawn, I don't care, you make a big deal of this and say, Mr. and Mrs. Buyer, I noticed you like that property. And because I work for you, I want to make a note that those were GE stainless steel fridge and stove, because if we put an offer in on that property, I'm not saying we are, we're going to look at a couple other properties, but if we are, I want to protect you, because it's not good enough for me to just say the fridge and stove in the kitchen, because that could be switched around, because I want to protect you. Again, you're working for them and showing them you work for them. Number 3 is stigmatized property, and this is becoming big numbers. Best practices for stigmatized properties. Now, again, your 21 says very specifically in the Code of Ethics, a broker or real estate agent who has a client in respect to the acquisition or disposition of a particular interest in real estate shall take reasonable steps to determine the material facts relating to the acquisition or disposition at the earliest practical opportunity, and shall disclose facts. In many ways, there more and more stigmatized properties are becoming your responsibility as a buyer's agent. You have to talk about that. Now, we go on, you know, because a reasonable person's decision could make a difference whether they sell a house or how much they make or how much they purchase, et cetera, et cetera. So you have to talk to your buyers about stigmatized property. It may influence the conditions that are attached to the agreement. Right now, the big thing is marijuana, which is legal. Now, I would hope if you were talking to your buyers, and this is a stigmatized property you would talk to them about, you would be talking to your buyers and saying, now listen, is marijuana a big issue to you? And they may say, no, we do it ourselves and we don't care. Or they may say, yes, it is. So you may have to work around it and make sure that you put a clause in the offer that the sellers never had marijuana plants, even if it was legal in the house. You know, they legally could grow them. So you have to know what to do. And that's why you talk to buyers. For example, knob and tube wiring, kite plumbing. Kite plumbing pipes are absolutely banned. Previous fire, not a big issue, but somebody may say, oh no, we got a stigma about if there was a fire in the house before, even if it's been properly fixed, we don't want to do that. Grow-ops are always a problem. They have to be disclosed. But keep with that. So you're working with them and asking them questions. It's a non-physical, intangible attribute to the property that's psychologically emotionally responsive to them. Now, if you said to a buyer, you sat down and said, tell me, are there any stigmas that you don't like? And they go, I have no idea what you're talking about. So you're going to have to use examples. For instance, the marijuana plants. And they go, oh, okay. Or for example, you know, if somebody died naturally in the house, would that bother you? To certain ethnic people, it does. To other people, they could care less. And that's fine. But you need to ask the question, you know, is a crib death different? Would that be a matter to you of an infant dying? Would that bother you? You know, if somebody died in the house 25 years ago, would that matter to you? So these are things, these are little things you can bring up to the buyers. And now they get the idea, oh, okay, I understand stigmatized properties. So it's important for you to discuss it as soon as possible. Another one can be fun, which is true though. You know, what about ghosts? And they go, yeah, okay. Well, technically that's a stigma. So give examples. You represent the buyer. You have an obligation to talk to them about that. Again, they're going to love you because you've talked to them about it and they didn't get into a problem and you are upfront with them and ask them all the right questions. Number 4 is warranty or a waiver. Now, this is a real complicated lawsuit, but I make it very simple. The agreement of purchase and sale requires the seller to complete certain repairs by a specific date. That's what it said. The home inspection was completed, and after the date of the condition was to be met, the buyer discovered the following were not completed. The repairs to the roof were not done as required. Regarding the grading around the property, obviously it needed to be graded properly, it wasn't. The vent stacks were not installed as requested. A report from the fuel oil distribution was not available. So the buyer's lawyer, which is interesting, the buyer's lawyer advised that if these 4 things were not complete, they would not close the deal. The seller's lawyer advised that if the buyer didn't close, they would resell and sue for damages. The buyer didn't close and the seller sued, and this is a true lawsuit. What was the decision of the court? And if we had time and I was in front of you, we could have this great discussion. But the point is, the buyer lost. Because if you notice in this clause, there was nothing that said what would happen if this was not done. It just said it will be done. Failing which this offer shall be null and void. Failing which we will hold back money. Something of that nature was not there. Now, what should have happened, and the buyer's lawyer, I think, gave very bad advice. What he should have done is close the deal and then sue the seller for the repairs. He likely have won that case. But to not close because it's not. And it all comes down to what's in the condition and the warranties and what did you write and not write. So make sure it's written properly. You know, my example is the buyer is concerned. You showed the property and he's concerned with all the junk in the backyard, or the basement is full of junk, or whatever it might be. and he wants the seller to make sure it's cleaned up before he moves. He says, well, I'd like to buy this property, but I want all this junk out of the backyard before we move. How do you handle this problem? And my point is, you sit down and ask them specifically. Now, are you telling me, Mr. Buyer, that if this isn't cleaned out, you don't want to ever buy this property? And he goes, oh, no, we like the property, we just want them to do it. Well, we're going to approach this in a different way then. And you have to ask them about it, because you don't want to because I can put a condition in the offer to say, this offer is conditional upon the junk being removed from the backyard, and then we're going to inspect it 3 days before closing, and failing which we'll hold back 10 grand, or failing which it'll not close. When you present this to the seller, he may say no, and the whole deal falls apart. What you're likely saying to the buyer, if we're going to put in a clause, a warranty, that basically says the seller agrees that he will clean the junk out of the backyard, as complicated as you want to make it, on or before closing at his expense. Understand, Mr. Buyer, there's no condition to this. If he doesn't do it exactly as you think it should be done, we can complete it, you can get it complete, and if it's costing you a lot of money, we can try and sue him in small claims court. But there's a different way, so you talk to them about that, so they understand exactly. You work for them, but you need their opinion. Do you talk about the waiver? This condition is included for the benefit of the buyer and may be waived at his sole option by notice in writing to the seller within the time period stated herein. That is there. The waiver is for the benefit of the buyer. Did you tell the buyer that? Did you say to the buyer, you know what, we write these conditions, and you don't have to say precedent, but the conditions are written another way, so it's to your advantage. So if we put in a condition on home inspection or financing, let's put in a condition on financing, and all of a sudden, mom or dad, or you win the lottery tomorrow night, this condition says, I don't have to get the financing. I can remove the condition. A good example of that today, and I know it's a crazy, crazy market out there today, but it will change again, is, the buyer puts in an offer on the condition of buying this property on the condition they sell their property. And they put an escape clause in. Well, it says very specifically, this condition is included for the benefit of the buyer. So in other words, if we get notice that we have to sell our house, we've only 2 days notice in the escape clause or whatever it might be written, the buyer can simply say, no, we're going to buy it anyway. But we don't have to make that decision until we're pushed to it. So explain to them the purpose of the waiver condition. It's for the buyer's purpose. If you meet the conditions, do you use a waiver and notice of fulfillment? And I'm sure most of you do a good job of this now. But you would use, if you meet the condition, you always use a notice of fulfillment. If you use a waiver, it's gone. Now, so in other words, if you can't, it's conditional on buying the property, selling your house, and you didn't sell your house, and you want to waive it, then you use a waiver. But if I sell the property, then I use a notice of fulfillment. Conditional offer on financing. If I get the financing in place, then I don't waive it, I use a notice of fulfillment. And it's not a big issue, that big, but the problem is you tell the buyer, I work for you. And the reason is we put a notice of fulfillment in, because what that means is the condition is still in the offer. If for some reason on closing, the condition wasn't met to exactly what was stated, then we have we have an argument to say this is what the condition meant. If we waive it, it's gone. So if you waived all the conditions and you went to court, the judge would say you paid $500,000, period, end of story, we're done. But if you put a fulfillment in, he may say, oh, okay, you're right. You didn't fulfill the condition as was stated. It's important. Oil tanks, not a big deal, but they're still important to talk to buyers about. You ask if oil tanks, and I'm talking about oil tanks above ground, not in ground, in the basement or they're in the cottage or something like that, and they're around there. Ask the listing agent the age of the oil tank. If it's 10 to 15 years or older, or that age, it may have to be replaced for insurance purposes in the buyer. So you would say to the buyer, you know what, if we ever find a house with oil tanks, the first question I'm going to ask the real estate the listing sales agent is, how old is the oil tank? Because if it's 10, 15 years old, we may have to replace it, and that may be an extra $1,000 out of your pocket. Or maybe I put in a condition in the offer that the seller will replace it. I don't care what you do. I'm saying you talk to them. It shows you know what you're talking about and you protect them one way or another. I'm sure all of you have tried this small little tip. I've used this many times. You know, the oil tank adjustment to the advantage of the buyer. This is only done in the summer, not in the middle of January. But all I'm getting at is, if you were showing a property in July and it's going to close in September, and there was a half a tank of oil in the grass or propane or whatever it might be, put in the offer, because I work for the buyer. If you are offering on the property with the oil heat and it's off season, place a statement in it that the offer that there will be no adjustment of oil on closing, because you know that normally what happens, the seller's lawyer will say, fill up the oil tank, and then we will credit in the statement of adjustments the whole full oil tank to the buyer. So it may cost them $400 or $500. Mr. Buyer, I understand. Now they could clean it out and they won't, but anyway. But so in other words, if I was working and saw a propane tank or an oil tank that was half full, I'd say to the seller buyers, you know what, if we buy this property, we're going to put a clause in the offer that simply says there will be no adjustment of oil tank. I'm going to save you a couple $100. They think you're wonderful because you talk to them about it. To thrive in life, we need 3 bones: the wishbone, the backbone, and the funny bone. Deposits. What I'm going to talk about now in deposits, you go, we know the answers to this. And yes, you do, but do your buyers? So do you tell your buyers why you need a deposit? It's good faith and part of the purchase price. In other words, if you give me $5,000 and the offer is $500,000, guess what? You only pay $495. Now, we think that's pretty trivial, but to some people that means a lot. And it's good faith. It just shows you're interested in the property and you're putting your money where your mouth is. Our deposit isn't cashed right, it's just kept in trust. Many times we say to people, well, we just hold it in trust for you. To many people, that means not cashed. So all of a sudden it's cashed and comes out of their bank account. They go, I thought you told me you hold it in trust. We're holding it in trust because it's yours. We're holding it in, the real estate company have to hold it in trust because it's technically your money to be used on closing, but it means it's cashed. If the home inspection is not satisfactory to me and I terminate, do I get my deposit check back immediately? So Mr. Buyer, whenever we put in an offer and we'll give you a $5,000 deposit, and let's say we had a home inspection and it wasn't satisfactory to you and we terminated the deal, it may be a couple of weeks to get your money back. There is nothing in legislation that says it has to come back at any time. You need to get mutual releases signed. For sure, the listing agent, if they're or brokerage, if they're holding it, will not release the money if it's not cleared. But some offices have policies, they only write checks once a week. So it may be next Friday before we get it. So just make sure they understand, you know, it's going to be terminated today. It doesn't mean by tonight you're going to get your deposit money back. How long do I have to get the check to you if my offer is accepted? I think this is the most abused thing we have. What your agreement says is 24 hours, and that's otherwise stated. So if it says 24 hours, it means 24 hours. It doesn't mean, there's nothing that says excluding Saturday, Sundays, and holidays, or when I want to get to it. It means if it was signed at today at noon, by tomorrow at noon, it better be there. My point is, if you get deposits that are reasonable and you talk to them about deposits, it's much easier to get them to bring the deposit money with the offer. Now, because you're presenting it today, let's have bring the $5,000 deposit with it. I put it in, I bring it back, and I know we're talking about electronic signatures and it's not as easy as it is. But if you can get the deposit money, get it. It saves you a lot of time. But explain to them we have to get this money up front. I'm sure some of you do this, but all of you should be doing it. How do you explain to your buyer regarding deposit insurance you pay for them? You pay every year $400 and some dollars, like $425 or $450 a year for insurance. And you think it's a lot of money. It's not, but it is a lot of money. The point I'm making is it covers 3 areas. It covers E&O insurance, commissions, and buyer's deposit. So my point is, when you get a deposit from a buyer, you say to the buyer, Mr. Buyer, I want you to understand something. This deposit is going to be held by the listing brokerage. And I don't know if he's good, I think he is, but if for some reason this buyer, this brokerage goes bankrupt or takes off with all the money, I have paid insurance that protects your money. You're going to get $5,000. If you give me $5,000, you're going to get $5,000 back. And that should be one of those things you tell them when they think you're wonderful. But tell them, I paid insurance to protect you. Remember, the protection with RICO insurance is for up to $100,000. And it's 0 deductibility. So in other words, if I give you a $10,000 deposit and the insurance and they take off with all the money, and that some will do it someday, you get your $10,000 back. Nothing more, nothing less, but I will get it back for you. Up to $100,000. Now, again, if you want to use an example and show them how smart you are, likely you don't get very many deposits over $100,000. It may be if it's a commercial deal or there's a very high-end deal, that's fine. But if I was getting over $100,000 deposit, I would make it in 2 deposits. I would say, we're going to get $100,000 is going to be held by the listing brokerage agent or brokerage. And the other $50,000 is going to be held by the lawyers in trust. Because you see, I have insurance, but it only protects you up to $100,000. So if you write a check for $150,000 in deposit, and for some reason the broker takes off with all that money, I can only get you $50,000 back. But if we give it and split it up with the lawyers and such things, it's better. So again, they think you're wonderful and they think you know what you're doing. RICO insurance claims since September of 2000 to 2018. I can't give you 19 because they didn't break it down. But deposit, just for a matter of interest, almost $6 million was paid out in deposit insurance. So if somebody says, yeah, but it doesn't happen, you go, well, yes, it did. The insurance company have paid out over $6 million in deposit insurance. Commission insurance, I just throw this in. This is to 18, not 19. 11 million, almost $12 million. E&O insurance, and this is really interesting, claims are 1,682 claims, which represents $166 million. So there's a lot of insurance claims being paid out. E&O insurance claims in 2019 increased by over 200 from 2019. So there was 1,359 claims in 2019, which was up 200 from 2018. So it's a very big. And believe it or not, and I was really amazed at this myself, 65% of the claims settled are all over $250,000. So it's not cheap insurance. The one I'm talking about today is deposit insurance. Number 7, preparing the offers. Now, this next question I put in here is a loaded question. Your buyer indicates that they are interested in 2 Lilac Court. What are the questions you need to clarify from the buyer in preparing an offer? And the point is, that's a loaded question. If you have done a good job of talking to your buyer and talking about their needs and wants and talking all this, the only thing you need to know from them is how much are they going to pay. You're never going to say to them, well, now, are we going to, I would hope in your conversation with them, you've talked about closing. Is it a 60? Are they on a month-to-month basis? Are they on a lease? Do they have a house to sell? If they do, it would be the same of that thing, whatever it might be. So all of these things, and yes, you may do it. And I hope you've talked about deposits. When we get an offer, I expect a $5,000 deposit. So there's no question about that. All I'm asking is, how much is it we're going to put an offer in for? And they tell you, and then you type the offer. You don't need to know anything more. Now, there may be minor things to, for instance, if they were in a month-to-month basis and they're going to give 60 days notice, it's going to take 10 days to get financing. Now that may put them, so you may say to them, well, we have to give 60 days after that. So this date, the 30th of January, why don't we move it out back to the 27th? It's not on a holiday or etc. So you're going to ask a little bit. But my point is, you're not going to sit down long about this. Schedules in the listing. Remember that schedules are not mandatory, and people put lots of schedules in listings. You and your buyer may not agree with all of them, all the contents for you. So you have to decide what is best for you, buyer, and what's not. Now, the seller's agent and the seller may not accept your changes, but that's a negotiable item. And I hear this all the time. Well, there's a Schedule A, you didn't put it in. I'm sorry, we can't agree with the Schedule A, we're not putting it in. Or you changed it. Yes, I did, because I can't agree with all the terms, because I work for the buyer. Now, again, in negotiating, if you read through it and there's something in there that you look and you go, oh, that doesn't really matter one way or another, you let it go. I mean, you don't make a big issue of it. But if there's something that's very important to the buyer, you have to talk about it. Low or multiple offers, deposits. Your buyer indicates they wish to make a low offer just to see what you're thinking about. Can you refuse to take the offer? And the answer is no. Your buyer is your boss. You have to make an offer. But how do you handle this situation? And as I said, I'm going to do this very quickly, but this may be a 20-minute conversation with your buyer. I'm not talking about a buyer that lowballs everything. Now, those buyers you may get rid of. You go, we've put in 10 offers and everything's lowball and this is nuts. I'm talking about a buyer who legitimately wants to buy the property. My argument is too, when you work with buyers and show them 3 or 4 properties or 5 properties or 10 properties, they get to know the value. They know this property is worth this or not worth this. I mean, they not know exactly, but they know it's, if I buy this one, like for this much money, it's a lot better than that one that was listed for that. So my point is, you talk to them about this, and I'm sure most of you do this already. But they say, because they just don't, they say, well, it's listed for $495, and from CMAs, and your business, you see it's worth $485, $490, and I understand in this marketplace it's a crazy market. You may not know that, but it's going to settle down. In fact, I was talking to 2 or 3 salesmen across the province this week, and they said their market is settling drastically. So it will change. So I'm talking about in a normal market, whatever that is. So it's worth $490, $485. And they said to you, well, let's put an offer in for $450 just to see what's going on. The point is you have to take the offer. But maybe I talk to them and I sit down and I say, Mr. Buyer, let me ask you a question. Let's assume you were the seller of this property. And it's worth, I don't know what they'll take, but let's say you thought in your head you'd take $485, $490, and there's someplace. And I brought you an offer for $450. What might you do with that offer? And what you want them to get around to show is that they get mad. They may rip it up. They may write it back for full price. They're agitated, whatever. So let me ask you this question then. So we got that through. So now if we made an offer though, and again, you're going to take $485, $490, and I made an offer for $478 or $475. What might you do with that offer? And if you were the seller? And now you want them to talk about the fact that, well, we're close, maybe not enough, but it's close and whatever, and they're not upset. It was a fair offer. So my point is, maybe they'll write it back because maybe they'll get $478, maybe they'll take $480 because they want to sell the property. I don't know. All my point is, Mr. Buyer, if we make them a reasonable offer, and this is good negotiating, if we make them a reasonable offer up front, there's a possibility we'll buy it cheaper in the long run. But if we insult them up front, coming in, they may write it back for full price, or they may not even write it back for full price, and it makes it very awkward. So you try and get them to see the light. Your buyer is in multiple offers. What is automatically recommended to the buyer regarding deposit? If I'm in a multiple offer situation, you get the deposit up front and accompany the offer. And that may be where they won't let you go with the offer. Well, that's not, we're going to get into that a little bit. But then I would take the offer to the listing salesman and say, here's the check, because he has to present it. If you can go with the offer, it's better. You're bringing it out and they say, oh, here's the check for $15,000. I know of all kinds of deals that have been made because it was sort of $2,000 or $3,000 different, but somebody brought the check and that was enough to the seller to say, no, we're going to take that offer. So don't be afraid to do that. Your buyer indicates that mom and dad would be providing the deposit. How would you recommend the buyer handle this deposit? And again, when you sat down and talked to the buyer, you got FinTrack filled out and you talked about deposits. And they said, oh, mom and dad are going to supply the deposit of us $5,000. Oh, that's wonderful. That's great. Now, let me ask you the question. Would mom and dad give you the deposit up front and put it in your bank account? And you got to give them a reason. And the reason I'm saying that is, and I'll do this if we have to, but if mom and dad give me the check from their bank account, I have an obligation under FinTrack to go and get them, I have to get a form filled out for them, and there's all this identification they have to identify. Not a big deal, but your mom and dad may not like that. So if they give you the check up front, we don't have to worry about that. It may be enough for them to do it, as long as you tell them why you want to do that. But so many salespeople, agents, never bother to talk about this, whatever. This is so important to talk about all the time. Wills, another important subject. Explain to your buyers the importance of drawing up a will that you've now purchased a property. And ask your lawyer. And my point is, we're not making a big deal here. But if I had a first-time buyers, I did this all the time. You'd say to them, Mr. and Mrs. Buyer, give a will. They go, what do we need a will for? We don't got nothing. Oh, yes, you do. You now are getting a house. And chances are you have mortgage insurance on that house. And I hope this never, ever happens to you. But if something happens to you, or one of you, with a will, it's very specific what happens, and it's cleaned out. Because if you don't have a will, it just gets more complicated from the legal point of view. You know what? I'm going to recommend to you when you get, because again, Mr. and Mrs. Buyer, wills are not complicated. They can be very simple. What's his is mine, and what's hers is yours. And if both of us are killed in a car accident or something, it goes to the children. Or if there's no children, it goes to your parents, whoever you want to do. It doesn't mean it's not a big deal to do, but wills are so important. So you know what? Ask your lawyer when you're drafting, chances are when he's closing the deal, he'll draft it for no charge or very little charge. He's saying, oh, I'll put a will in, sure, for a couple $100. Ask him, what will you do for me? Now, again, you don't make a big issue out of this and keep saying to the buyer, did you get your will? Did you get your will? I did my job. I talked to them about it. I'm there. But it shows you're concerned about them. I know in my career, and I'm sure you can tell me exactly, if you can, that's really good to tell your buyers. But in my career, I had two situations that I can think of where one was they bought a house and the lady never moved into the house because she took cancer, a young couple, and she took cancer and died. And that was tragic. But it was there. They had a will, though, and helped at all situations. Mere postings are the same as private for sales. The same thing, really. And I'm not going to spend a lot of time on that, but I'm going to do something. Why are mere postings good listings for your buyer? Or why are private for sales good? Because you're the boss. You're the agent. You represent them. The mere posting or the private for sale is a customer. If you're going to show a mere posting or a private for sale, what should you ask the buyer representation to obtain from the seller before? You either use a 201 or a private for sales agreement, but you should get the money up front. How much are they going to pay you if you sell this property? It's too late when you get the offer and you go in with it, because now you can't negotiate. Because again, most sellers, and we're talking a little bit about sellers, but if I was the buying salesman going in And I said to the seller, what will you pay? And he goes, oh, I'll pay you half a point. And you go, well, the problem with that is I have an agreement signed for 2%. And if my buyer, when I go back and tell him that he has to pay another 1.5% himself or 1%, he may say, forget this property, we'll move on. So I want to show your property, Mr. Seller. Listen, you're the boss. You know the bottom line, and he doesn't, but you know the bottom line. You know how much money you need for the property. So why don't you give me 2%? When I bring you an offer, if I'm able to bring you an offer, I bring it in, you have final say. You know, if it's enough money to cover all what you want, then you can accept it. If it's not, you don't have to accept it. You can write it back or not accept it. You're the boss. You've got to tell them those things, though. The buyer likes the property, wants to prepare an offer, so you advance. What are the advantages in presenting the offer? The advantages are you're the client who represents the buyer, and the seller, private or mere, is a customer. So what do you need? What do you need to ask the seller to sign at the time of the presentation? Oh, this is not a big issue, but a private for sale or a mere posting do not have to sign FinTrack form. So you should ask the seller in a mere posting if he'd like to sign a FinTrack form. If he goes, no, I'm not signing it, you go, fine, just fill it in on represented. It's not a big deal. That's not the course for this. The seller indicates that he wishes to counter the offer back to the buyer for $10,000. Can you assist the seller in writing this back? Absolutely. I didn't give him advice. He said to me, I can't take $490, I want $500. Can you help me? And I go, sure, let's change the $490 and write in $500, et cetera, et cetera. I can do that because I'm just assisting him. I'm not giving him advice. When you take the counter back to the buyer, what do you tell him? I tell him everything the seller told me. And this may be to the advantage of the buyer. Maybe the seller said to you, well, write it back for $500, but you know, I would take $495 if he really comes back. Well, I tell him that. Or you may be adamant to the fact that say to the buyer, you know what? I'm sorry, I just know from his attitude and the way he talked, 500 is the bottom line. You use it to your advantage because you represent the buyer. You make an agreement with the buyer and the seller to take a signed copy back to the seller. You made a deal. You take it back to the seller. And what do you say to ask the seller? You go, Mr. Seller, here, thank you very much for doing your job. You know, who's your lawyer? We'll send it to you, or you can send it to the lawyer. I need to know all that. The next question you ask them is, do you want to buy a house from me? Because most sellers want buyers' representation. It's very important. Number 9, offer presentations. What is your role, responsibility, and ethics in the presentation to your buyer? We do this not well, folks, and I understand there's all kinds of problems with this today. But if I represent the buyer, always ask the listing salesperson if you can go with the presentation or sit through a video communication. Today we're doing a lot of Zooming and video conversation. The offer, because remember who you work for. I work for the buyer. And you made a big deal of helping you representing the buyer, and then all of a sudden when it came time for the offer, the buyer said, well, how did the offer go? You go, I don't know, I just faxed it to him or emailed it to him. Well, come on, work with it. Can the seller keep your offer and counter a number? Absolutely. Remember, the law is very specifically, once the seller has the offer, the salesman, the agent has the offer, it's theirs to do whatever they want with it. And they can play your offer against everybody else's. Does the seller have to take the best offer in cash or condition? Absolutely no. That is why the more you can go with the offer or sit through a video, you can tell the buyer's story. And you may have a letter from the buyer to say they really love the property and they whatever. I'm going to play on the seller's emotions. And there's been all kinds of cases where a seller, and money is not important to an elderly seller, they like the buyers and they give it to them because I sold them on it. So don't be afraid to do this. No question about that. When the buyers are made aware that they are in competition, can they withdraw their offer? Absolutely, as long as it wasn't given to the seller or the salesman ahead of time. the agent. When the buyer is made aware, so maybe you say to the buyer, like, we're in a competition now of 5 or 6 offers. And you know what? My advice is, let's not put an offer in. I want to withdraw because I'm not going to get into a bidding contest. They may say yes, and that's fine, but you talk to them about it. Your job is to help them with the emotions. How can I deal with the listing brokerage who's insisting that all offers are emailed and does not allow the cooperating real estate agent to attend the offer presentation? And that happens today. I think, and this is not the course, another course I do this, but I think that really is listing salespeople sometimes are scared that, the buying salesperson is going to take over, agent's going to take over and tell them, no, it's my offer. I'm going to be the one that's in charge of it, but that's another story. My point is, if they insist that you can't go, you do not email it to them or take it to them ahead of time. So they say, well, just email it to me. And you go, no, I'm not going to email it. I can't go with the offer. When are you presenting it to the sellers? Well, at 8 o'clock tonight. Fine. At 7:45, I will either deliver it to your office or I will email it to you. But be damned if I'm going to give you this offer a long time ahead of time and let you play it again, everybody else against it. I work for the buyer. Why would you as a buyer representative ask that an offer be presented before it's stated that all offers would be presented, known as the bully offer? Why wouldn't I? My buyer is from Barrie, but he's leaving town today and he's going back to Vancouver. He wants to buy this house. I'm going to try and preempt the offer. Now, you have to talk to the buyer and tell them all the pros and cons, but I'm not going to sit back and wait. I have every right to ask them, do they want to get it presented ahead of time? They may say no, that's fine. What are the questions that the selling representative will likely ask to determine if he should go forward? Obviously, this is very true. If I called you and said, I have an offer that's only good till midnight tonight, not till next Friday, and they call the seller, what's the seller going to ask them? How much is it? So the first thing the thing is, I'm going to tell them, I have an offer, it's good till midnight tonight, and I want you to know it's full price, or it's almost full price, or there's no conditions in it. Something that makes it nice that they at least can talk to the seller to say, you know what, maybe we should look at this offer because it sounds like a good one. The buyer would like to reduce get a reduction in the original purchase price of the home inspection, indicating some unexpected repairs. This is an old question. This keeps coming up though. The buyer asked you to prepare for a $10,000 reduction in price and he would remove the home inspection. You prepare an amendment on the instructions. This condition is until 4:30 today. So last night he called you and he said, I looked through the home report as you've indicated to me too, from you looking through it, there's some problems with the house. You think this seller will reduce the price by 10 grand? I don't know. Let's put in an amendment and ask. So I prepare an amendment to say that we're going to do that. And I'm likely to talk to the buyer and say, if he won't give you the amendment, do you still want to buy the house? And he has 2 answers, yes or no. So that's fine. If he says, yes, I do, then I may get a notice of fulfillment also filled in, signed at the same time. Because I'm going to wait to see what happens. This condition is till 4:30. What I do for the amendment, and this is so important and people will really screw this up today still, is I only give them till 2 o'clock to accept the amendment. Because if I give them till 4:30, as a selling salesman, I'm sitting there waiting for your offer because at 4:30, I already have a better offer and I hope it falls apart. So you bring me in an amendment at 4:30 and I go, nope, the deal just fell apart because it had to be met by 4:30 and it's all over. But if I bring you in an amendment that says 2 o'clock and by 2 o'clock you can't sign it, I now have 2 hours to do, so I may come back and say, okay, thank you very much. Here's the notice of fulfillment. We're going to buy it anyway. This is up to us because I work for the buyer. The buyer is prepared to sign at 10 a.m. You call the seller representative and indicate that you're bringing in an amendment. What time would you make the amendment irrevocable? We talked about that, 2 o'clock. This is another big thing. If the listing, I see this all the time, in the listing or the real estate agent is asking for 48 hours irrevocable, when does the offer need to be presented to the real estate agent? I'm not going to give it to him 48 hours ahead of time. He may have a very legitimate reason why he wants to present it in 48 hours. Maybe it's an elderly person and the son has to be present or whatever it might be. Maybe they're truckers and they're out of town and need 48 hours to get back. I don't know, and that's fine. But so many people say, well, send me the offer. So I give him the offer 48 hours ahead of time. He'll play my offer against everybody else's, and you're going to lose. So when he said to me, well, I need 48 hours, I say, fine. Tell me when you're presenting. Well, Saturday at noon. Okay, we'll make it irrevocable until after Saturday at noon. But you're not going to give him the offer. People, well, I got to get, no, I don't have to give it to you. I have an offer. It needs to be presented. I'm the boss. If you find out, and you've all used this form, I'm sure, Form 109, if you find out you cannot go with the offer presentation, or it can nothing to do with it, then get an offer conveyance acknowledgement filled in. It's a very simple form, and you accompany it with the offer. What needs to be here is that the seller, rightly, if I was the selling salesman, in the comment you'd write across not acceptable. That's fine. But at least there's a proof and the seller signs it. There's at least proof that it was presented to them. And that's all you want to help yourself with the buyer, because the buyer says, how do I know my offer was ever presented? Well, at least if I put this form in. Now, again, I have to caution you that they may not fill it in, and there's nothing I can do about it. It is not a mandatory form. I think it's just bad ethics not to, but they can't. The last thing we talk about is number 10 is the commission compensation. And this is a quiz, compensation for a pop quiz answer. Is it okay to not show a property if the commission isn't high enough? And the answer is true and false. It is false. It's true to the fact that your code of ethics says you must show all property regardless of commission, etc., etc. But my point is, I work for the buyer, and I have a buyer representation agreement in place for 2%. And I say to the buyer, and all they're paying me is 1%. So I say to the buyer, Mr. Buyer, I can't get I tried to get an increase in price, but he wouldn't give it to me. And all I'm getting is 1%. And you know what? You may have to pay, you would have to pay the difference. And he goes, then forget it, move on. If the buyer tells you you're not going to show the property, that's fine. You can't tell the buyer that. You're not going to show it because of lack of commission. Now, again, with a buyer representation agreement, you may agree at the time that you're only getting 1% or 1.5%. You may agree with your buyer to say, for this time only, I will reduce my commission from 2 to 1.5. That's your business, nobody else's. If you show a listing that is not in the MLS system, you need to have written commitment. And the answer is absolutely true. If you have an exclusive listing, you need to get permission. So when I call you as an exclusive listing, I say, oh, Martha, you have an exclusive listing on such and such, and she says, yes. I said, can I work on it? She says, sure. My next question is, how much money are you going to pay me? And she will then say, well, I'll pay you the same as everybody else, or I'll pay 2% or 1%. Okay, now send an email to that effect. Martha, I just want to follow up. Thank you very much for allowing me to show the property. And this is just confirming that if I do sell the property, you will be paying 1% or 2% or whatever it might be. You have something in writing, because if you don't have it in writing, you may have trouble collecting commission. The buyer can ask the seller to pay the buyer's representative. And that's false. You cannot, and some people do it, but according to the lawyers and according to RICO and such things, and I agree with this, you cannot, the agreement of purchase and sale is between the buyer and the seller. You can't put a clause in the agreement to say the seller will pay you. I can figure it out ahead of time every other way, but not in the buyer, not in the agreement purchase and sale. The commission rate offered on the MLS applies to all agents licensed in the province. And that is absolutely false. Now, you're better off because today you have a great, with whatever your organization is called, there's 20, all those brokers are put together, you're protected. But if you were in a situation, say you were in Ottawa, and say you have a son or somebody going to somebody in Ottawa, and you saw a property there and you said, well, they're going to the University of Ottawa and you'd like to show it. So you called up Joe in Ottawa, it's an MLS listing, and say, Joe, can I show the property? He goes, sure you can. Yeah, you do it. Technically, it's an exclusive listing. So anything outside of your jurisdiction, and now this is important to you, your 20-some boards that are all a matter of members of Ortis, you're protected. But if you get into somebody, whatever, that's not a member of Ortis, for instance, Toronto, you would need to make sure to do it. It protects you. And I'll tell you, you people in Barrie, this is a true story. This was when the Parry Sound board was in existence. I had a call from a broker in Parry Sound who said he had a call from a salesman in Barrie that wanted to show his property on the MLS system. It was not interboarded or anything else. And he said, sure you can. And she sold it. After she sold it, he got a bill in the mail, and he said, I'm not paying her. I said, I don't blame you. She didn't ask for money. She simply said, can I show the property? He said, my attitude is she asked to show the property. I thought she was getting paid by the buyer. I don't have to pay her. Now, whether he did or not, I have no idea, but I agree with him. You need to ask permission. Again, it's just a matter of sending an email to say, thank you very much for allowing me to show the MLS listing such and such, and I'm confirming that the commission is such and such. Protect yourself. The buyer representation can use the purchase agreement of purchase and sale, to request a higher commission from the listing office only if they have an exclusive agreement with the buyer, and the answer is no. Again, as I say, you can't negotiate in the agreement of purchase and sale. I can negotiate ahead of time. I can negotiate through the confirmation of cooperation, but not through the agreement of purchase and sale. Ladies and gentlemen, I ran a little over time, but it's important. Technology will not replace real estate agents, but real estate agents who do not use technology effectively will be replaced by those who do. I thank you very much. If anybody wants the PowerPoint or wants to ask me a question, well, I'll take questions now, but in the future, if you have a question, just email me at hughfoy46@gmail.com, and I'd be more than pleased to try and answer the question. So I'm going to sign out and see if there's any questions. And maybe we've answered them all, and that's good.
You're just too good, Hugh.
Thank you. That's good. Thank you very much. I hope I helped some of you think of things to do. As I say, you're not going to use everything I talk about. I understand that because we all are individuals and we all do our own thing. But if I can help you in some way to just use it, try something, it's going to work for you better off. So, anyway, I don't see any other questions. That's wonderful. But if anybody has any questions, let me know. Email, and I'd be more than pleased. We'll be back to see you sometime soon. I don't know, Danielle and I have another sometime, but anyway, thank you very much, ladies and gentlemen. Have a great day, and good luck in your selling, and I hope your market settles down to a reasonable play. Thank you. Bye-bye. Good night. No, good afternoon. Good morning.